Hi, everyone. I'm Maggie McGrath, editor of ForbesWomen. On Monday, the Georgia Supreme Court reinstated that state's abortion ban on pregnancies after 6 weeks of pregnancy. Also on Monday, the U.S. Supreme Court failed to intervene in a Texas law that banned emergency abortions in cases of healthcare emergency. Joining us now to break down these two decisions is Michele Goodwin. She is a professor of constitutional law and global health policy at Georgetown University. She is also a bioethicist. Michele, thank you so much for joining us.
It's a pleasure to be here with you, and I'm really so happy that you are pushing forward with this really important platform.
Well, it's a little confusing if I'm being honest. I initially reached out to you on the news that Georgia had repealed the ban on abortions after 6 weeks of pregnancy, yet less than a week later, that ban has been reinstated. Can you talk about how it is that it has flip-flopped so quickly?
Well, this is the nature of what's been taking shape in American law after the Dobbs decision 2 years ago, which overturned Roe v. Wade and Planned Parenthood v. Casey. And in that decision, written by Justice Alito, the majority decided that these are issues that should be decided by the states, but they punted to states that have been quite conservative on questions related to abortion rights. And I want to just frame that a little bit, which is to say that these were actually not issues that were liberal or conservative for decades. Roe v. Wade was a 7-2 decision, and 5 of those 7 justices were Republican appointed. Planned Parenthood v. Casey, 20 years later, which reaffirmed Roe v. Wade, all 5 of the justices in the majority were all Republican appointed. And so what we see today is something that is actually far different than what the nature of reproductive health rights and justice had been. These were not matters that one could say were liberal or conservative, Democrat or Republican, because Republicans were as much, if not more so, supportive of civil liberties and civil rights as related to reproductive affairs. In the Georgia case, what has been noted in recent weeks was the deaths of 2 women that were related to their ability not to be able to obtain care following following pregnancies, and with having in one case seen doctors that would not intervene, and in these states you have doctors who don't want to intervene for fear of losing their licenses to practice, civil penalties as well as criminal punishment, and another person who appears to really have been afraid to even seek medical care. But you have a lower court order from a judge that really spoke to the pain and tragedy that has taken place since the Dobbs decision, speaking quite specifically to the fact that much of what we see has forced women who don't want to be pregnant into involuntary servitude for the benefit of others, which really strikes at the heart of what constitutional law is all about. And when we think about the new Constitution in some ways that we have that includes the 14th Amendment and the 13th Amendment, those amendments specifically were meant to address bodily autonomy, specifically matters of reproductive autonomy. And many Americans may not spend much time thinking about those matters, but those amendments were part of the Reconstruction, and the Reconstruction specifically related to matters of American slavery. And so built into this new Constitution that we have, right, these new amendments, the 13th, 14th, 15th Amendments, were specifically designed to respond to a time in which there were human beings that were denied their own bodily autonomy and integrity. And that included girls and women. And very specifically, you can see this in the writings of members of Congress at the time. I mean, it is explicitly there that they are talking about involuntary reproductive servitude. And they're talking about the exploitation that girls and women were faced with having to involuntarily carry pregnancies that they did not want. And so we see much of that kind of language and reference in the lower court decision. And then, as you mentioned, a flip that we've also seen take place in states. We've seen something similar in the state of Texas, though not with an overturn of their SB 8 ban, but we saw when Kate Cox needed to have a pregnancy terminated because it risked her future fertility and risked her life. and a lower court judge found that the state's abortion ban had an exception and that she qualified for the exception, then you found the Supreme Court of the state of Texas flipping on that and suggesting that she didn't.
Now, when you mention involuntary reproductive servitude, that is a stunning phrase that did you coin that? Because you were cited in the Georgia decision to repeal the ban last week. So is it anti-constitutional to put the ban back in place if you're arguing that the 13th Amendment is the basis on which the ban should be repealed? Did the Georgia... Yeah, go ahead.
Well, the 13th Amendment and the 14th Amendment, and yes, this has been wholly unconstitutional. And, as people think about these issues, could it be possible that the Supreme Court could ever rule on something and be wrong? Has it made rulings that are actually antithetical to constitutional principles and values? Yes. Yes, and I could give you a slew of cases. Some of them are familiar to your audience. So your audience would know about Karamatsu, the internment of Japanese Americans, only because they happen to be of a Japanese heritage. The Buck v. Bell decision, where the Supreme Court sanctioned a Virginia law that provided for the compulsory sterilization of poor white people, 1927, this case, which became the foundation for what was used in Nazi Germany. There are any number of cases, even thinking about the Plessy case, Plessy v. Ferguson, where the Supreme Court said it was totally fine to be separate but equal, where Black people could be segregated in some train cars and white people segregated in other train cars, which led to the era of Jim Crow. So does our Supreme Court, has it gotten it wrong in the past? Oh, yes, it has. Has it engaged in values where it ignores constitutional principles and values? Well, yes, it has. And that's not a stretch because I've just named some of those cases. And so with the Georgia court that has now overturned this lower court decision, yes, it shows a disregard for constitutional values and principles, not the least of which is the 13th Amendment, not the least of which is the 14th Amendment, and the entire Bill of Rights that speaks to individuals being protected from the tyranny of the state, which is really what so much of our Constitution is about. The fundamental principles in our Constitution are about protecting people from the pressures, the coercions, the exploitation, the harms from the state. And it goes beyond that, but that has really been the principle behind our Constitution.
You mentioned Amber Thurman's case. She was the 28-year-old mother who died in Georgia after doctors delayed treating her because of that state's abortion ban. And I'm wondering, is there legal precedent for a death like that, maybe not in reproductive health law, but in general health law, to then change the state's law? When you hear of a case like that, it's devastating and makes some think that maybe it's impetus for change.
Well, it's a brilliant question that you've asked, Maggie, and it absolutely should be the kind of impetus that we've needed. But I think what makes these times so absolutely egregious, and where we can see the absolute disregard that lawmakers have had, this kind of doubling down against women and girls, we saw that immediately after Dobbs, when a 10-year-old girl had to flee the state of Ohio to get to Indiana after a pregnancy caused by rape. And lawmakers in that state doubled down. They first said, well, this is a hoax, that can't happen, which of course is not true. So this is the other thing that we see in this space, where there are lawmakers who've shown a complete disregard and ignorance towards health and science. And after it was, a very spunky, plucky woman reporter said, it is true because I was in the courtroom when the person who was accused of doing this was prosecuted. And then you had lawmakers saying, well, okay, it's not a hoax, but our law has an exception. Well, then after you found the legislative staffers, each state has a branch of a library, essentially, that tracks the legislation, and they read the legislation, and they are experts, and they can determine what the state's law actually says and what it doesn't say. So after those experts who are hired by the state, who do this work of reading the statutes, they said, well, no, actually, there is no exception in this statute that makes room for a 10-year-old who's been raped to be able to have an abortion. That strikes me as much like this. Those lawmakers then didn't go back and say, well, let's repeal the law. Let's rewrite this law so that it has exceptions for rape or incest. Let's rethink it altogether because we shouldn't be in the business of doing this. We're not doctors after all, and we're not parents of these people. Instead, in Ohio, what you found are anti-abortion lawmakers doubling down in every possible way. And it wasn't until a group of medical professionals decided that there needed to be a ballot initiative in Ohio that would protect their interest to serve their patients and for patients to get care, then did the law fall. But that was not because lawmakers themselves said, oh, this is really a bad idea. And we see how people are being hurt by this. And I will say this, that even in Ohio before the ballot initiative, there was the case of Brittany Watts. Brittany Watts, a woman who sought medical care 3 times while experiencing a miscarriage and sent home each time, and then had a miscarriage at home. And it should have ended there, along with a notation that how tragic that she had been turned away 3 times and that she suffered and that she was in pain and her life was at risk. But after she had the miscarriage, police raided her home, raided her bathroom, busted open her toilet, searching for fetal remains and fecal remains. And then she was charged, criminally charged. Ultimately, the case was dropped, but was being charged for desecration of a corpse. And you can't make this up. And again, it was an opportunity for Ohio anti-abortion lawmakers to say, we got this wrong. This is not the kind of thing that we should be doing. In Georgia, there is this opportunity now for lawmakers there to say, this is not the type of thing that we should be doing. This is not the kind of state that we wish to be. It's worth noting that Georgia is a state that is a former slave state. And I think we can't ignore that. For so many people, I think they see this as not a connected issue. But let me tell you how it is. It's a connected issue because in the states that practice human enslavement, human bondage, that practiced involuntary servitude, that knew that there were people forcing girls and women to carry pregnancies that they did not want, forcibly impregnated. And in those states, they didn't decide on their own. There were some states that did decide to get rid of that practice, New York, Vermont, New Hampshire, etc. Georgia was a state that did not decide to get rid of it on its own. Mississippi was not a state that decided to get rid of it on its own. South Carolina was not a state that decided to get rid of it on its own. Texas was not a state that decided to get rid of it on its own. Alabama wasn't. And so what does that mean? We actually had to fight a civil war in order for those states to stop practicing this. There had to be a constitutional amendment, which was the 13th Amendment, followed by the 14th Amendment, to get these states to stop practicing this. So for those that don't understand this through line, history informs us in very deep and profound ways.
What does that mean for the current environment? You mentioned Ohio lawmakers did not learn from the women who had been harmed by that state's abortion laws. There's an opportunity perhaps to change in Georgia. So maybe let's just start in Georgia. What's next for abortion policy in Georgia, if anything?
Well, there will be a challenge to now the overturn of this district court opinion. It may make its way before the Supreme Court. The Supreme Court could decide that it doesn't want to hear this. But I will say, as a national matter, what we have teeing up are multiple things. We see more of the anti-abortion stance and the doubling down on an anti-abortion stance. Well, at the same time, there is a flurry of cases coming out from these very states of women suffering, of deaths, of rapes, of children going to school now as mothers, right? I mean, it's a bevy of this. It's an overflow of this. Just 2 weeks ago, I was giving testimony before the Senate Finance Committee, and there on that panel was, I've now been on several of these panels with women who have suffered, who were in near-death circumstances post-Dobbs. And so more of that we will see indicated. We will see more ballot initiatives where there are doctors or patients or civil society organizations taking these matters to voters because voters do not want these abortion bans. And really what we've seen as part of that cohort of women who've suffered have been people that wanted their pregnancies but suffered miscarriage or were suffering other kinds of conditions, because 20 to 30% of pregnancies don't end in a birth, and not because of abortion, but because of miscarriage and stillbirth. And I think there's another part of this that we'll see too, Maggie, and that is there's a Project 2025. There is a real effort to try to federalize through Congress enacting law that would codify aspects of these abortion bans that we've been seeing at the state level. So there are multiple prongs to this, not just one.
You mentioned the state by state bevy of cases. One of those cases concerning emergency abortions in Texas, the U.S. Supreme Court declined to intervene. Later this week, there will be a hearing on an abortion ban in North Dakota. What are you looking at the closest? Does one of these cases stand out over the other in terms of what it could mean nationally, or are they all equally important?
Well, let's start with this EMTALA decision because that's really important. So EMTALA is the Emergency Medical Treatment and Labor Act. It was enacted by Congress in 1986. It was enacted during a Republican administration, and further during the Bush administration, Bush 2, it was found that yes, as part of emergency treatment, abortion is on the agenda. If an abortion will help to stabilize a woman, if it will help to resolve her health issue and the crisis, then she should be able to have an abortion. So prior to this period of time, it was very clear that these were medical matters, that reproductive health care is health care. Reproductive health care requiring a pregnancy termination is health care because it can help to save a person's life and it can help to save their quality of life. And I think that that's really important too, because when you look at where the needle has moved, there is the attention on death. And that is really important because there are people who have died. And I think that there are more cases of people who have died that haven't even made the news. And so the Emergency Medical Treatment and Labor Act is supposed to protect people against this. And the Supreme Court heard a case earlier this past term, and made their decision over the summer, which was basically on procedural grounds. It involved Idaho standing down the federal government, saying that the Biden administration, saying that EMTALA applies to cases where there's a need to manage miscarriage and cases where a pregnancy would be, where an abortion would be indicated. The Biden administration said EMTALA should cover that, and that federal law preempts states' law. Now, this is Law School 101. And for more than 200 years, it's been an accepted notion and principle in a law for more than 200 years that the Supreme Court is the Supreme Court of the land, and that Congress and federal law is the supreme law of the land. And so by the fact that the state of Idaho said we don't have to listen to the federal government, it should immediately have been something that the Supreme Court would strike down, because for more than 200 years, we've understood that when the federal government speaks in protecting of people, that is the law. And I'll give you an example that's apart from reproductive health rights and justice, where folks who are tuning in can understand. In 1964, after seeing all of the horrors that Black people were experiencing in the American South in Jim Crow, every nature of it, Congress enacted the 1964 Civil Rights Act. This was meant to protect the civil rights and civil liberties of Black people who were living in places where they couldn't walk into the park by law, where they couldn't swim in the swimming pool by law, where also many things that the laundry list of them are too long to even mention, but many of us know how horrific Jim Crow was. In 1965, Congress passed the Voting Rights Act to protect Black people's right to be able to vote. We all know the story of Black folks trying to cross the Pettus Bridge and being met by law enforcement on horses and with batons and beating them because these people wanted to exercise this constitutional right to be able to vote. We understand that those federal laws will trump any state law that says, no, Black people, you cannot vote, right? If the state of Idaho if the state of North Dakota, if any of these states passed a new law saying we've decided Black people can't vote, we would know that that is unconstitutional. We have federal law that protects people's ability to be able to vote. But what we have now in the space of anti-abortion lawmaking is we don't have to listen to the federal government. We don't have to listen to the federal government when it says we have a law that protects all Americans who are in a health emergency. They are to receive care, and that care should be determined by their doctors and not by lawmakers, right? And let me give you just one more example, Maggie, and I appreciate you indulging me with this. Imagine this. Imagine that there were some lawmakers that decided they really needed to tighten the economic belt, the budget belt of the state. And they decided suddenly that, well, when a person comes into a hospital who, is having a heart attack, that they've suddenly decided, well, you know what, aspirin. We're just going to say, we're going to direct all hospitals to now, when that person's dying and having a heart attack, just shove some aspirin down their mouths and send them away, or just give them the aspirin and tell them to go home. We would know that that would be ridiculous because the Emergency Medical Treatment and Labor Act covers the stabilization of those people. Don't send people home who are having a heart attack. We would know that that is illegal and unlawful. This is the equivalent, though, of what lawmakers are now saying. We don't have to listen to this. We can make the determinations and not doctors. And we are essentially saying, go home and take an aspirin. And that is what is being said to women in crisis right now.
And we could probably spend the next 5 hours talking about why it is women in crisis are treated this way and not a heart attack. But what I want to ask you, Michele, is the Supreme Court of the United States being consistent in how it rules on these EMTALA cases? Because to my very untrained eye, it feels like what it decided regarding Texas emergency abortions is different from what it decided in Idaho's emergency abortions.
Right. So what it did is it refused to take up the Texas case. Hear no evil, see no evil. In the Idaho case, it said, we'll send this back for it to be further developed through the lower courts. So, and it is being further developed through the lower courts, and then that's where it stands. The difference happens to be between the two cases, the potential of what that looks like in the development of this Texas case and what a lower court decision would look like, which could be that a determination that EMTALA does not reach abortion in the state of Texas, versus, as you were noting, in the Idaho case, where the result may be very different. We don't know yet how these will come out, but what we do know, and what Justice Ketanji Brown Jackson emphasized in the opinion that she wrote in the EMTALA case involving Idaho, is that the Supreme Court should have done more. It was within their power and authority to do more. The court didn't need to rule on this as a procedural matter, where the court just said it was too early for it to take this on, that it was a mistake that the court took it on. Instead, what the court could have done was to be clear about 200 years of jurisprudence, which is that federal law trumps states' laws, and that substantively EMTALA, which is not an unconstitutional statute, it has never been a statute that's been claimed to be unconstitutional at all, that this is a valid statute, and the application of it in these circumstances is a valid application of the law. And that's what the court could have said. That is actually what the court should have said, but it didn't.
Do you think it is kicking the can down the road until the presidential election is over? And perhaps part B of that question is, will they start taking up these cases in 2025 after a new administration has taken the Oval Office?
That's possible. And what you're hinting at is something that up until a few years ago, there would be law professors and scholars of the law who were far more, I think, gracious in their opinion of the court and their assessment of how the court deliberates. there would have been feathers being ruffled by saying that the court engages in outcome determinative rulemaking. There would have been the sense that no, each case is decided on its own, on the merits. These are not cases that are decided with a political partisanship in mind, that we know judges and justices have their own ideological leanings, but nothing more than that to in any way influence a decision. I think that most persons in legal academia and those who engage with the court would have framed things in that way, even if they had some personal misgivings. And that is because I think the court has been revered as an august body, and the perception is that it is a very objective body. But as we started this out, there are times in which the court has gotten it wrong, and gotten it decidedly wrong in ways that are inconsistent with the Constitution and inconsistent with human rights and inconsistent with morals and values. And I would say that in the space of this now, that yes, this is a court that is engaged in opportunistic originalism. Yes, it's a court that has been outcome determinative. We saw that just with Dobbs. And let me give you an example of it so that it is clear. The day before Dobbs, the court issued a decision in a case called Bruin. Now, on the court, there are several members of the court who claim themselves to be originalists, that what they like to do is to look back to original text, which is been interpreted as looking back some time ago to see what people originally meant. They want to be clear about the text. Well, the day before the Dobbs decision was a case called Bruin, and it involved more than a centuries old New York law, which was a gun control law in the state of New York, more than a centuries old. So it's old, quite original. And its meaning could be found in the text of the law, as well as by the deliberations that took place at the time in which the law was enacted. It was a case that was written, the opinion was written by Justice Thomas. And in this decision, Justice Thomas said that he needed to provide a prologue for us to truly understand what was at stake in the case. And it's unusual that you would have a prologue in a judicial opinion. And in this prologue, you have Justice Thomas spending 5 paragraphs talking about the importance of bodily autonomy and the importance of Black male bodily autonomy, and making a connection between bodily autonomy, Black male bodily autonomy, and their entitlement to guns, right? In order for Black males to be full constitutional citizens and to have their full constitutional rights and their full autonomy, they need access to guns. And he spends 5 paragraphs and he talks about, a Black guy who was a school teacher, a Black guy who was a professor. And in all these instances, if only they had had guns, their full constitutional personhood could be recognized, their full bodily autonomy could be recognized. And so you know where I'm going with this. The next day is the Dobbs decision, and the court makes no reference to bodily autonomy whatsoever. It makes no reference to Black women and their bodily autonomy. The case itself, Dobbs, comes out of the state of Mississippi, a place that for centuries denied Black women bodily autonomy, and denied them bodily autonomy up until the 1960s, where Fannie Lou Hamer talked about the Mississippi appendectomy and Black women like herself being coercively sterilized because they were seeking government benefits. Not one word from Justice Thomas about Black women and bodily autonomy. Not one word from Justice Alito, who wrote the majority opinion about bodily autonomy and women or Black women. So yes, does this court selectively engage in how it pursues its jurisprudence, what tools that it uses to reach its outcomes, communities that it finds some favor with, arguments that it finds to be favorable in one instance and not the other, bodily autonomy mattering if you want a gun, but bodily autonomy not mattering if you want an abortion? That's this Supreme Court.
That is the Supreme Court, at least for the time being. Well, Michele Goodwin, thank you so much for joining us to break down the constitutional law involved in Georgia's abortion ban and the abortion landscape in the U.S. as a whole. We will have to have you back as the court continues to rule on the bevy of cases that still exist. But for the time being, thank you so much for joining us.
Thank you so much. I look forward to coming back.